And this even applies to people that want to get a religious marriage. So if you take two Catholics, for example, they go through a certain process. They've got to be very intentional about the fact that they are having a religious marriage. And, within the Catholic doctrine, marriage is indissoluble. And yet, so two people do this, they go through all of the steps. It is a religious marriage. And yet the state can come into that institution and say, you know what, sorry, we are going to allow this to be destroyed at will. It was never an area that the state should have had that involvement in. And the reason I say it is this: can a state go into a church and tell the pastor, sorry, you are baptizing people the wrong way? Can the state go into the church and say, sorry, the way that you are celebrating the Lord's Supper or communion, whatever you want to call it, this is the wrong way. This is a state approved way. So these are institutions of the church that we say right offhand, the state has no involvement in this. The state cannot come into the church and determine what religious doctrine is. The state cannot say, well, we no longer believe in the deity of Christ or something like that. The state can do whatever it wants to do, but it has no jurisdiction within the church. And for two people who, from a religious perspective, enter into marriage within the dictates of their faith, the state really, in my opinion, should have, if they have any, if they can make a claim to any type of jurisdiction, it should be very, very limited. And I think a strong argument could be made to say no jurisdiction. What are your thoughts regarding that?
Yeah, this raises a whole can of worms because it's very deeply rooted in history, and the traditional churches, the Roman Catholic and the Orthodox churches, did not have a view of civil society in which the separation of church and state existed. I mean, there was some kind of distance, but there wasn't full, complete separation. And so what you see, and the history is very interesting because Rhode Island was the first state to enact this kind of establishment clause, which was in effect caused the separation of church and state. And a lot of people don't realize the difference between the free exercise of religion clause and the establishment clause. One refers to your behavior and the other refers to your viewpoint or ideology, let's say. And so in the first case, where the freedom to exercise religion, basically the state can't make laws to impede upon that except for narrow reasons, like you said, limited reasons, limited jurisdiction. So the state has to prove, that there's a compelling state interest, that it's narrowly tailored, and that the law results in affecting that state interest. So just like, people may say, well, their religion allows them to make animal sacrifices. Well, or, practice polygamy or something out in Utah, which didn't happen. It was a Supreme Court case. And the court came back and said, well, we can't make laws against your views, but we can make laws against your behaviors. And so, so that's the religious exercise clause. The establishment clause puts an absolute prohibition on the state's regulation of your views. And so that's where we get into this realm where, whether it's called irretrievable breakdown or whether it's called irrevocable breakdown. I mean, there's all these, fancy words in Texas. It's incompatibility. They all mean the same thing. Right. But essentially what that is it's a viewpoint, and it's the subjective viewpoint of the spouse pursuing the divorce. And so you no longer have a law, a cause of divorce action that is based on behavior. You don't have a law that's regulating a type of conduct. What you're doing is the state is now creating a law that actually endorses someone's subjective viewpoint that the marriage is irretrievably broken. And that's where the problem lies. Because again, the argument here that a lot of people, and especially law attorneys, try to conflate is that they're saying, you and I, Jeff, are, we want to, destroy divorce completely and, eradicate it completely from the face of the earth. And, not only is that unattainable, but it's probably not desirable in the grand scheme of things. I mean, considering all the situations out there, and again, religious people, non-religious people, it just wouldn't work in our type of society. But the issue is no-fault divorce, because it says if one spouse has their subjective viewpoint that the marriage is irretrievable, that again, there's no evaluation of conduct, even though again, they'll later say, well, there was this and that and the other thing, but that's not what the law says. Right. The law doesn't regulate behavior.
Yeah.
And so that's the issue, and that's why it's a religious issue, even if you're non-religious, because the Establishment Clause is not about just formalized religion. It's about viewpoint. It's about your ideology or your way of thinking, whether that's religion or whether it's not. But either way, the no-fault statute targets viewpoint as opposed to conduct, and that's therein lies the issue.